The Law of Self-Defense content you are about to enjoy is presented for general educational purposes only. It does not constitute legal advice. If you are in need of legal advice, consult competent legal counsel in the relevant jurisdiction. Hey folks, welcome to our ongoing coverage of the Minnesota murder trial of Derek Chauvin over the in-custody death of George Floyd. I'm Attorney Andrew Branca for Law of Self-Defense, providing guest commentary and analysis of this trial for Legal Insurrection. Today's content is sponsored by CCW Safe, a provider of legal service memberships, what many people mistakenly call self-defense insurance. CCW Safe, in effect, promises to pay their members legal expenses if their member is involved in a use of force event, and those expenses start big and get bigger fast, folks. A typical aggravated assault charge, which can happen if you simply point your gun at another person in self-defense, don't fire a shot, don't hurt anybody, can risk a 10 or 20-year felony sentence and cost as much as $30,000 to $50,000 in legal fees to defend, and that's just for the pre-trial expense. If you don't have that kind of money stuffed in a mattress, just in case you're compelled to defend yourself or your family, it can be useful to have a financial partner standing behind you to make sure you have the legal resources you need to fight the legal battle the way you'd want it fought. Now, I've looked at all these types of services you might imagine, and I found that CCW Safe is the best fit for me. I'm a member. My wife, Emily, is a member. Whether they're the best fit for you is something only you can decide, but I do encourage you to take a look at what they have to offer by pointing your browser to lawofselfdefense.com/CCW Safe. And if you do decide to become a member of CCW Safe, you can save 10% off your membership at that URL, lawofselfdefense.com/CCW Safe, using the discount code LOSD10. That's LOSD for Law of Self-Defense and the number 10. By the way, anyone interested in a free podcast version of our daily legal commentary and analysis of the Chauvin trial can access the Law of Self-Defense News and Q&A podcast. It's available on most every podcast platform, including Pandora, iHeart, Spotify, Apple, Google, or even just a simple RSS feed. To find a connection, if you can't do a search on those platforms, you can always just point your browser to lawofselfdefense.com/free podcast, and it'll provide all the links you need. Now, before I jump into the substance of today's testimony, I'd like to make a concession, or at least a change of opinion, with respect to defense counsel Nelson. During jury selection, there were numerous instances in which it appeared to me that Nelson was being overwhelmed not just by the quantity of prosecution counsel — there's 10 or 12 prosecutors working this case and only one Nelson — but also by the quality of prosecution counsel. The concern I had was that perhaps Nelson was simply not up to this case. My concession is that after watching Nelson working in the trial proper after jury selection, I've been extremely impressed by his performance. While it's hard to score the lawyer until the very end of the case because you never know what they might be intentionally delaying or holding back as part of trial strategy, or how they'll perform when it's time for them to be on offense during their case in chief rather than on defense while the state calls witnesses, I'm pleased to be able to say that Nelson is performing at a level vastly greater than I'd feared might be the case. So, Counselor Nelson, I tip my hat. And with that out of the way, today's court proceedings brought us 5 more state witnesses, and once again, none of today's state witnesses appear to substantively advance the state's narrative of guilt, which has never all that clearly been stated even in opening statements, and in any case, all provided gems useful to the defense narrative of innocence, or at least, more technically accurate, the defense narrative of not guilt. Today's witnesses consisted of one Courtney Ross, Floyd's co-addict lady friend; Seth Bravender, the driver of the ambulance that arrived on scene and a paramedic; Derek Smith, the second paramedic on the ambulance; Jeremy Norton, a captain on the Minneapolis Fire Department, who also responded to the scene; and David Ploger, the now retired MPD sergeant who was in charge of the officers involved with Floyd's arrest. So let's start with the first of the state's witnesses. That's Courtney Ross, who shared Floyd's drug addiction with him. They met as addicts, and who has been variously characterized as Floyd's girlfriend or fiance. I'll note that it's been my experience in these politically charged cases that often the most tenuous of romantic relationships may get recast as a formal betrothal to provide some social credit that might otherwise not exist, and it's impossible to really determine the true nature of the relationship. Accordingly, I'm falling back to my grandmother's description of such things and referring to Ross as Floyd's lady friend. Direct questioning was conducted by prosecutor Matthew Frank and, of course, crossed by defense counsel Eric Nelson, the only lawyer on the defense quote-unquote team. At this point, it perhaps goes without saying that Ms. Ross also had a catastrophic emotional breakdown on the witness stand, complete with sobbing and gasping and tears. She partly explained her reaction by noting how devastated Floyd had still been over the loss of his mother, appealing, of course, to the video of Floyd calling out "Mama" as he died. This whole bucket of emotional appeal would take on a very different air once Ross was subject to cross-examination, as we covered in our blog post this morning. I'll touch upon that again here for those who might not have seen this morning's blog post. Generally speaking, Ross testified with the kind of evasiveness and half-truths we've come to expect from state witnesses, including telling part rather than the whole truth, in response to defense questioning, at least, claiming she couldn't recall what she'd previously told investigators and compelling the defense to refresh her recollection with transcripts. And this only goes one way, folks, it seems, with these witnesses. The only forgotten prior testimony is that which would have been helpful to the defense. And more of all that with Ross, as we've seen with other state witnesses as well. Now, I already covered the two most notable aspects of Ross' testimony in our breaking post this morning, which I'll link in the text version of today's content. In that blog post of this morning, entitled "Chauvin Trial Breaking," Mama was George Floyd's nickname for his drug-sharing girlfriend. I wrote about the revelation disclosed on cross-examination by the defense that Floyd's pet name for Ross and the moniker under which he had her listed in his cell phone was Mama. Was she the mama he was calling for while restrained on the street? I also wrote about Ross recounting that Floyd had experienced a previous overdose in March 2020, taking pills similar or identical to those he took on May 25th, during which she had to bring him to the hospital because he was experiencing intense stomach pain, much as he was experiencing on May 25th when restrained by police after self-ingesting a bunch of these pills in an effort to avoid their discovery by police. Further, Ross herself had back in March taken some of the same pills and reported to investigators that she thought they were going to make her die, much like Floyd was saying he felt he was going to die while restrained on May 25th after his self-ingestion of similar pills. Ross also noted that her normal opioids were relaxing and took her pain away, but these strange pills acted as a stimulant, such that she was jittery and couldn't sleep all night. She had also told investigators that in the March overdose, she observed foam around Floyd's mouth, just as his mouth was foaming on May 25th. Now, this is important evidence because of the state's argument in opening that it couldn't have been the fentanyl in Floyd's system that killed him, because fentanyl, an opioid, makes people sleep when they overdose on it, and Floyd was clearly not sleeping. To the extent the drugs ingested by Floyd also contained methamphetamine, however, and we know that the found pills on scene contained both fentanyl and meth, then they also contained a stimulant, as well as an opioid, which could explain Floyd's energized state in forcibly resisting lawful arrest against multiple officers for some 10 minutes. The meth would also explain why Floyd's pupils didn't demonstrate the pinprick constrictions of fentanyl overdose, but were instead dilated, a condition the state used to argue again that it could not have been fentanyl that killed Floyd. His pupils were dilated, but that dilation would be induced by the meth component of the drug cocktail. All of this, of course, suggests an alternative cause of death other than Chauvin's knee, and that is the self-induced overdose of Floyd via that pill ingestion on May 25th. Cross-examination also revealed that Ross had told investigators that she believed Floyd to have been clean, meaning off drugs, for a substantial period of time leading up to May 25th, perhaps right up until just 2 weeks prior to his death. This clean period suggests all kinds of considerations with respect to the question of tolerance, which in turn touches on whether Floyd had such a high tolerance to his drugs of choice that even a 3-fold fatal dose might not be able to kill him. Now, I hesitate to dive into these issues in depth because I claim no expertise in the medicine of illicit drugs or drug addiction or tolerance, other than that gained by having interacted with addicts and people who treat addicts. That said, I don't believe tolerance works to make an addict more resilient against death by overdose. I think it merely makes it harder for the addict to get the desired high. The mechanism of death by overdose and the mechanism of the high are fundamentally different. The brain develops tolerance to the drug and so requires a greater concentration of drug to get the same high, but that has nothing to do with how the drug kills. In the case of fentanyl, death is usually the result of the drug achieving a level sufficient to stop respiration. I don't believe the body develops any tolerance to that biological mechanism. In other words, if an addict first needs 2 units of a drug to get high, he'll eventually need 4, then 8, then 10, etc. to get that same high. But if a fatal dose is 20 units, then whenever the addict hits 20 units, he dies. And it matters not a whit how much tolerance he's developed in the context of getting high. Indeed, one of the great dangers to addicts is that they grow ever closer to the fatal overdose level as their increasing tolerance to achieving a high demands higher doses that approach ever closer to fatal levels. Again, however, I caution that's a layman's understanding of these issues. I look forward to hearing expert testimony during the trial. We also learned from Ross that the passenger in Floyd's car, Maurice Hall, the man who had earlier tried to pass a bad $20 bill to the clerk in cup food and had been rebuffed, was apparently Floyd's drug dealer, or at least one of them. This provides some insight as to why this man's legal counsel suddenly, just yesterday, announced that his client, if called to testify in Chauvin's trial, would refuse to provide testimony and would plead the fifth. If I were the drug dealer involved with the fatal overdose of a client, I suppose I'd be pleading the fifth as well because I'd be liable to a murder conviction. Interestingly, the pills that caused Floyd's hospitalization because of the intense stomach pain and that acted as a stimulant on Ross back in March were essentially identical to the pills consumed by Floyd on May 25th, 2020, the day of his death. I would also note that if the state wanted Maurice Hall to testify, that is, if Hall's testimony was going to be favorable to the state and increase the prospects of convicting Chauvin, the state could simply immunize Hall from prosecution and compel him to testify. You have no Fifth Amendment right if you've been immunized. You're no longer under legal jeopardy. The fact that the state is not doing so strongly suggests that they have reason to believe Hall's testimony would be favorable to the defense and decrease the prospects of convicting Chauvin. That's justice, folks. Redirect of Ross by Prosecutor Frank came across as particularly weak, I thought. He asked Ross if Floyd had died in his March overdose, taking essentially the same pills. Obviously, if he took them in March and he didn't die, that must mean it's physically impossible for Floyd to have died of the same pills on May 25th. After all, the overdose in March merely hospitalized him. Surely that means they can't kill him, right? I mean, it was just silly. Unfortunately for Frank, Ross's response to this line of inquiry only helped the defense. I mean, how often does that seem to happen with these state witnesses, right? When Frank asked her, in effect, hey, he took the pills in March and they didn't kill him, right? She answered, no, they didn't. In fact, he had a lot of energy. Again, driving home the role of the stimulant, methamphetamine component of the drug cocktail in all of this. Well, the video of Ross's testimony on direct, cross, and redirect is all as separate components embedded in the text version of today's content. The second of the state's witnesses today was Seth Bravender, the driver of the ambulance that responded to the Floyd scene and a paramedic who helped provide care to Floyd, as well as driving him to Hennepin County Medical Center. Direct questioning was conducted by Minnesota Assistant Attorney General Erin Eldridge. She's apparently one of the few of Attorney General's Keith Ellison's actual staff attorneys whom he trusted to participate in this case. Most of the other prosecutors on the case are high-end private attorneys brought in specifically for the purpose. Cross-examination was, of course, conducted by defense counsel Eric Nelson, again, the only attorney on the defense quote-unquote team. An early interesting reveal in Bravender's direct testimony arose when Eldridge asked him to describe his training. He noted that he'd first been an EMT, and that required relatively little training, a 6-credit college course, but now he was a paramedic, and that took a year-long course of instruction. This is notable because while MPD officers will have had some first aid training, they are not trained to even the level of an EMT. That's the standard for the Minneapolis Fire Department, but not the police department. That means that the first aid training of MPD, Minneapolis Police Department, is way, way below that of the paramedics who were en route to the Floyd scene with Code 3 lights and sirens. Would it be reasonable for a police officer trained below EMT standards even, much below paramedic, to simply wait the mere couple of minutes he expected it to take for the highly trained paramedics to arrive, rather than attempt to provide basic first aid in a busy street and in the presence of an angry and hostile mob threatening imminent physical violence? I would think so. It's also notable that Bravender noted that the time interval between receiving the Code 2 medical call for Floyd, the non-emergency medical call, and the Code 3 emergency medical call, lights and sirens, that was only about a minute and a half. It wasn't as if the officers on scene waited 10 minutes before escalating the call from Code 2 to Code 3. They saw that Floyd had bloodied his nose in resisting arrest, called the Code 2, then within 90 seconds escalated that to a Code 3 when they realized Floyd was in greater distress than a bloody nose could explain. That strikes me as fairly prompt. Bravender also provided important testimony that buttressed the defense argument that the angry, hostile, and imminently threatening crowd was an important factor in decision-making at the scene. Bravender and his paramedic partner, Smith, the next witness, both quickly decided to do a load and scoot on Floyd, rather than attempt to treat him on site, in part, I expect in whole, because of the presence of the angry mob. In fact, the ambulance ended up driving 3 blocks away before it parked, and both paramedics were available to provide care to Floyd. Now, the state tried to undercut this view of the mob as angry and hostile and threatening in 2 rather dishonest respects, frankly. First, Eldridge kept asking if anyone in the mob had actually attacked the officers or paramedics. Of course, that's not the point. The mere presence of a threatening mob is sufficient to influence decision-making without having to experience an actual attack. You don't want to be attacked. That's the whole point of load and scoot, is to get out of the area before you can be attacked. Second, Eldridge repeatedly conflated the matter of moving Floyd into the ambulance, where the paramedics' equipment was located, and moving Floyd 3 blocks away, long blocks, from the scene before providing care so that the mob could be escaped. By conflating these two, she's suggesting that the reason for the move was simply to provide Floyd with better care, and by implication, not to escape the mob. Providing better care is certainly the reason to move Floyd into the ambulance. That's where the gear is. But it's certainly not the motivation providing him only limited 1 paramedic care until the ambulance is driven 3 long blocks away. Those are 2 separate things, moving into the ambulance and moving 3 blocks away. Now, a key theme hit by Eldridge repeatedly through her directive Bravender was the notion that Floyd's death was a result of a delay in beginning chest compressions, and by implication, therefore, the death was a result of the police not beginning chest compressions earlier, before the paramedics arrived. After all, however limited their medical training, anybody can do simple chest compressions. This failure constitutes an unlawful killing, is the idea. Of course, this begs the question that the officers knew chest compressions were appropriate, necessary, and likely to make a life-saving difference. First, I question whether the officers had this subjective awareness. We heard repeated testimony today, or saw it on video footage, of the various officers attempting to assist the paramedics in helping Floyd. And this is all besides making the medical calls already in the first place. Chauvin himself helped get Floyd onto the gurney and helped guide the gurney to the ambulance. Another of the 4 officers, I forget now which, but whose body camera ID ended in 507, actually joined Floyd in the ambulance in Chauvin's direction and provided chest compressions to Floyd while the ambulance drove those 3 long blocks away from the mob and until the fire department arrived at the ambulance. That strikes me as unlikely conduct for a bunch of racist police murderers. The direct questioning of Bravender by Eldridge further provided support for the defense narrative of the angry mob when the camera footage, the body camera footage of the paramedics on the scene was played. This is body camera on the officers. The paramedics don't have body cameras, but we can see the paramedics through the body camera of the officers. We can clearly hear the voice of MMA expert Williams, as well as that of 1-year off-duty firefighter Hansen, clearly calling the officers the B word. Hostile? Once again, overall, I thought the effect of the direct questioning of Bravender was more helpful to the defense than it was to the prosecution. On cross-examination by Nelson, more points were scored for the defense. In particular, Nelson did a good job on cross in getting Bravender to acknowledge the very different roles of the police on the one hand and EMS on the other. For example, it's the police who have to deal with the danger of the scene. EMS will stage some distance off and wait for a code 4, all safe, before coming in to provide care. Bravender also recounted coming upon scenes frequently in which police were struggling with a suspect. On another important issue, Nelson asked Bravender if sometimes people who overdose become violent when they are resuscitated or regain consciousness. Although the state objected, Cahill allowed the question, Judge Cahill, and Bravender answered in the affirmative. Indeed, Bravender testified he'd personally seen it happen. Further, Bravender testified that when they were called out on an overdose call, so it's a known overdose call, it was standard practice for them to be accompanied by police precisely because of the heightened danger of such circumstances. Bravender also agreed. He told earlier investigators that when he arrived on scene, Floyd was on his left side. This is important because the state is in part arguing that Floyd died of positional asphyxia because he was kept prone on his stomach and should instead have been in the quote-unquote recovery position. Well, the recovery position is to be up on one side of the body, and the left side suits this purpose just fine. Thus, Bravender's description placed Floyd in precisely the recovery position the state argues was appropriate. Nelson also asked Bravender if the ambulance carried ketamine, and when the answer was affirmative, Nelson asked why. The answer, of course, is that ketamine is a powerful sedative that can be used to calm violently resisting suspects, many of whom are violent because of drug overdose. This both highlights the risk police officers face in handling overdose calls, but also provides a subjectively reasonable basis for the officers to want to wait on the ketamine-carrying paramedics they believe to be moments away, rather than provide care to the apparently overdosed Floyd themselves. So Bravender was subject to direct, cross, and redirect, and those are included as separate videos in the text version of today's content. Also subject to recross, I believe. Yes. So the next witness was, state's witness was Derek Smith, the paramedic partner of Bravender. Bravender was the driver and a paramedic, and Smith came across as the senior paramedic of the two. Now, I'll jump right to the money on Smith, and this occurred during his cross-examination by Nelson when Smith expressed the belief that there was no reason the cops couldn't have started chest compressions on Floyd sooner. Now, I'm sure those on the Lynch Chauvin now bandwagon will take this statement as some kind of definitive proof that Chauvin is criminally responsible for Floyd's death. But of course, it's nothing of the sort. First of all, there's no way to know if providing chest compression earlier would have been of any use to a badly overdosed Floyd with existing serious hypertensive and cardiac disease and a threefold fatal overdose of meth-fentanyl drug cocktail in his system. Absent Narcan, which the officers didn't have, they would have been doing chest compressions on a patient likely already dead and who was otherwise beyond saving with the means they had at their disposal. Further, Smith's comment is from the perspective of a paramedic with the narrow mission of saving the life of his patient. He knew nothing about what had gone on before he arrived on scene, nor of the many policies and tactical considerations relevant to the police, but not to himself as a paramedic. After all, Smith had the option to load and scoot Floyd and immediately evacuate the presence of the angry, threatening mob, all the while able to rely on being defended by the officers if things went bad, and that's exactly what Smith did. Chauvin and the officers did not have the option to simply run away. To put it another way, just because Smith would have preferred that the officers had provided chest compressions in the presence of the angry, threatening mob and on a busy street, even if it would have added as little as 1% better chance of survival for Floyd, and that's understandable for a paramedic, that opinion is completely detached from the broader context with which the officers were obliged to deal. It's merely an opinion of Smith's and not an authoritative conclusion, frankly, it's a poorly informed opinion. Otherwise, Smith's testimony was rather boring. In essence, the entirety of his testimony was that Floyd was apparently dead when Smith got on scene. He was dead when the ambulance fled the 3 blocks. He was dead when the fire department finally joined the ambulance. And he was still dead when the ambulance dropped him off at the Hennepin County Medical Center. As with Brovender in direct of Smith, Prosecutor Eldridge pushed hard on the notion that Floyd's death could be attributed to this transient delay of the officers in providing earlier care to Floyd. But again, all this ignores the tactical environment in which the officers were making these decisions. Smith was subject to only direct examination by Eldridge and cross, of course, by Nelson, and the videos of each of those are embedded in the text version of today's content. The next state's witness was Jeremy Norton, a captain with the Minneapolis Fire Department, and the bottom line with Norton was I really didn't see his testimony as being all that helpful to the state, except perhaps in acting as a white knight for off-duty firefighter and bystander witness Hansen, who, of course, testified earlier in the trial. And to the contrary, chunks of his testimony again struck me as favoring the defense. Yes, again, another state's witness whose net testimony appeared to benefit the defense more than the state. Folks, it's hard to overemphasize how familiar this pattern is to me, based on my experience covering the George Zimmerman trial, probably because of similar drivers. Both of those cases being apparently politically motivated prosecutions, lacking the substance necessary for an evidence and law-based finding of guilt. In any case, again, Prosecutor Eldridge led direct here, and it was just boring. If anything, it made the fire department look bad. First, the fire department received a Code 2 for a minor mouth injury, just like the paramedics. Then it was upgraded to a Code 3 for lights and sirens, again, just like the paramedics. When the fire department actually got to Cup Foods, however, the ambulance had already fled the angry mob. As a result, the fire department personnel basically looked around, saw nothing, no patient, entered Cup Foods looking for a patient, again saw nothing, and finally came across a police officer in the back of the store who told them they were supposed to be meeting the ambulance 3 long blocks away. So they loaded up back on their truck and took off to find the ambulance. I would suggest not exactly a sterling example of professional performance. Now, in fairness, perhaps this wasn't the fault of the fire department. Maybe they did everything perfectly. But it certainly was not the fault of the police officers whose only role is to make the medical calls to dispatch. After that, the call is out of the officer's hands. They're presuming they called the Code 3. Medical personnel are coming with lights and sirens as quickly as they reasonably can. And the more it looks like that call was out of the officer's hands, the more it looks like fault may lay in hands other than the police, and the weaker the prosecution's narrative of guilt looks in this case. On cross-examination, Nelson again scored important points, this time walking Norton through the timeline of events involving when the police placed their medical calls and when the fire department actually showed up. And that time interval was approximately 12 minutes, vastly greater than what off-duty firefighter Hansen claimed was typical for response time in her testimony. And presumably this 12 minutes was much longer than the officers on the scene could reasonably have expected. Now, again, maybe this 12-minute response time was no fault of the fire department. Who knows? But it certainly wasn't the fault of the officers, and accordingly, again, diminishes the prosecution's narrative of guilt. On redirect, Eldridge tried to do damage control on this time interval by conflating the time interval between when the police made the medical call and when the fire department arrived on the one hand, with when the fire department received that call and arrived on the other hand. Now, that latter interval may be important in determining fire department performance, but it's irrelevant to the reasonable perceptions of events by the officers on the scene. All they knew was they'd made the call for Code 3 medical and the fire department wasn't there yet. And when the fire did show up, it was too late. Now, Norton was subject to direct by Eldridge, cross by, of course, Nelson, and redirect by Eldridge, and the video of each of those segments is included in the text version of today's content. Now, the last witness of the day was David, I'm going to mess up this pronunciation, I apologize, Pfluger, I believe. He's now retired, but on May 25th, 2020, Pfluger was the MPD sergeant responsible for the precinct zone in which the Floyd event took place, and a supervisory sergeant over Chauvin, Tao, King, and Lane. Pfluger was questioned on direct by Prosecutor Schleider and on cross by, of course, Nelson. Now, Pfluger struck me as testifying with no particular bias. Although, of course, he exists within the larger political dynamic of Minneapolis and a year's worth of propaganda around the case, and it would be difficult for that to have zero impact. Still, he struck me as giving pretty much a just the facts testimony. It appeared to me, however, that the prosecution had placed a large bet on Pfluger. Specifically, the state wanted Pfluger to testify before the jury unequivocally that Chauvin's continued use of the knee restraint in the 3 minutes or so between when Floyd appeared to stop moving and the paramedics arrived, that this was an excessive use of force, period. Because of his even-handed testimony, however, I expect people watching Pfluger will draw from his testimony whatever it is they most want to see. When asked by the prosecution if it wasn't true that sometimes police officers used more force than the circumstances called for, Pfluger answered in the affirmative. Conversely, when asked by the defense if it wasn't true that sometimes police officers were compelled by circumstances to use more force than might otherwise be the case, Pfluger again answered in the affirmative. Well, both of these answers are correct. The appropriate amount of force is determined by the totality of the circumstances, and it's both true that greater force than necessary under the circumstances is excessive and unlawful, and that the circumstances may require a greater degree of force than might otherwise be the case. In the case of Prosecutor Schleider, he was looking for Pfluger to make a blanket statement that Chauvin's knee restraint was excessive, period. Schleider wanted this opinion to be based on Pfluger's experience doing use of force reports as part of his job as a police sergeant. Nelson, of course, wanted to emphasize the circumstantial dynamic of use of force situations. Further, he objected to the state's efforts to extract a definitive, authoritative use of force opinion specific to this event because Pfluger had not comprehensively reviewed the use of force evidence in this case. Specifically, although Pfluger as a sergeant would routinely review, in a comprehensive manner, routine use of force events involving his officers, once an event was escalated to a so-called critical incident, as happened here in the death of a suspect, the case of Floyd, the use of force investigation then was escalated out of his hands to higher authority. As a result, Pfluger never did anything like a thorough use of force investigation in this case. It was appropriately taken away from him. At most, he'd reviewed the body camera footage, and even that only at the late request of the prosecutors. As a result, the defense argued in a period during which the jury had been removed from the courtroom, precisely to allow this argument out of the jury's hearing. The defense argued that Pfluger might be able to provide the jury with a use of force opinion, but only an uninformed opinion, not an informed opinion, much less an authoritative decision. After this argument outside the hearing of the jury was called back in, and Judge Cahill allowed Schleider to ask Pfluger a very narrow use of force question, and Schleider got the answer he wanted, but the context was so tightly constrained that I don't see it as having caused much harm to the defense. That said, were I the judge in this case, I'd not have permitted the question, given Pfluger's relatively uninformed state on the use of force facts of this particular case. But in any case, of course, we're going to see a great deal of additional use of force testimony to come in this trial. Now, because of the jockeying between the state's efforts to drag a purportedly authoritative use of force call out of Pfluger and the defense efforts to foil this, poor Pfluger was subject to direct by Schleider, then cross by Nelson, then redirect by Schleider, then recross by Nelson, and finally a redirect by Schleider. The videos of all that, plus the argument between counsel that occurred outside the hearing of the jury, are all included as separate videos in the text version of today's content. Okay, folks, that's all I have for all of you today. Join us again tomorrow for our live coverage of the court proceedings in Minnesota versus Chauvin, and for our end-of-day wrap-up commentary and analysis, both right here at Legal Insurrection. Until next time, I'm Attorney Andrew Branca for Law of Self Defense, providing guest commentary and analysis for Legal Insurrection. Stay safe.